So in this video, we'll be taking a look at the salient features of the LLP Act, that is the Limited Liability Partnership Act of 2008. So as we discussed in the previous video, a few points will be repeated here. Now the LLP has a separate legal existence. It's a separate legal entity distinct from its partners, which is very unlike a traditional partnership. The feature of limited liability, so it has this advantage that every partner is liable to the extent of his contribution to the LLP, and no partner will be held personally liable for any debts of the LLP. His share in the assets maximum will be used to settle the dues, but not his own personal property, again distinct from a traditional partnership. Then an LLP is formed on the basis of an LLP agreement, a proper written agreement which is to be signed between the partners, defining their rights, duties and obligations. Then the accounts of the LLP. So LLP is under obligation to maintain their annual accounts, and they have to file it with the ROC every year, the Registrar of Companies. They have to file it regularly on an annual basis. Then they cannot be very slack about these things, because there is a fine for late filing. Then number of partners, minimum 2 partners are required to form an LLP, and minimum 2 designated partners are required to function very nearly like directors of the like in directors in any company, like that the designated partners function. They need a DIN, directors identification number. They need to register on the MCA portal. Then merger and amalgamation can be carried out as far as LLPs are concerned. So there is a compromise or arrangement could take place warranting a merger or amalgamation of 2 or more LLPs. Then investigation into their affairs, wherever the government organizations think it necessary, or the government thinks it necessary to investigate into the affairs of the LLP, they may do so, just as they do in case of companies. Then private companies or public limited companies also may choose to convert into an LLP just for ease of functioning and fewer compliances when compared to their own compliances which are required under the Companies Act. And LLP may be wound up when partners no longer wish to continue with the business. So it can be wound up either voluntarily, or it can be wound up in a mandatory manner by the tribunal which is established under the Companies Act. And until the establishment of the tribunal, the power for winding up rests with the High Court. Then applicability of the provisions of the Companies Act is that the LLP Act is applicable, plus the Companies Act is applicable to an LLP. Then the Indian Partnership Act of 1932 is not applicable to an LLP. So I hope this video was informative, and that you will be taking a look at the subsequent video on partners and designated partners in an LLP. Please don't forget to hit like and subscribe. Leave your feedback and comments. Thank you. This is Dr. Mariam Narona.